Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 7. In terms of the material that we're covering in the weekly sessions, you'll note that we're behind from that which is the scheduled reading. So over the next few weeks, I will slowly but surely catch up. But just to finalise our commentary in relation to conciliation, bear in mind that there is no clear definition of mediation or conciliation, and the lines sometimes blur. So that which some people call mediation might look to others like conciliation, and to some degree vice versa. But the processes, of course, are similar. So if you had to write an assessment piece as to the similarity and differences between mediation and conciliation, there are not necessarily right or wrong answers, but there are some guidelines. So the similarity, of course, both involve dispute resolution practitioners as a third party. And as the ADR practitioners, the mediator or conciliator control the process. So that's common between the two, and of course the aim is to work towards a resolution. The process is somewhat similar in that in both instances, the ADR practitioner helps the parties to identify the issues, generate options, consider alternatives, work towards an agreement, encouraging all the time the parties to communicate with each other in a confidential forum. In both instances, the ADR practitioner does not have a role to determine the matter, take sides, or tell people what to do or what decisions to make. But the level of suggestions to which the ADR practitioner can extend does differ between the two. Now, attendance at conciliation conferences is sometimes compulsory, whereas a mediation tends to be a voluntary process, but still there are circumstances, particularly under court annexed or tribunal annexed procedures, where mediation is compulsory. The conciliator, but technically, theoretically, it should never be compulsory. The conciliator, of course, as opposed to a mediator, can make some authoritative statements as to the legal position, and in some circumstances, and with great care, a conciliator may interrogate, or even, if you like, cross-examine the participants, generally doing that in a closed or private forum, but do so guardedly, and open-ended questions is always preferable. The dispute resolution practitioner is a positive or proactive intervener in conciliation, and that can include by adding agenda items for the discussion, whereas strictly in a mediation session, the parties generate the process of identifying the issues. I'll give you an example of what I mean by that in terms of a concrete example. In a family law dispute involving children, sometimes the parties to the dispute forget that it's all about the child. And the principles in the Family Law Act are that the paramount consideration in all decision making must relate to the child. So that's section 65E of the Family Law Act. Therefore, it's entirely appropriate for the conciliator, in effect, to champion the values of that statutory scheme and to include a specific agenda item in relation to the paramount consideration, the best interests of the child. Sometimes the parties will resist that. So the conciliator is more actively encouraging the parties and than a mediator perhaps, but it is a question of degree. But in general terms, a conciliator can be, for want of a better term, more robust in the way in which he or she conducts the ADR session. And the conciliator, of course, can provide to some degree expert advice on likely settlement. Mediators won't do that. So the mediator can generally, theoretically, only take the relatively soft option of asking parties to reconsider the perceived benefits of litigation, whereas the conciliator can make some statement as to the likely outcomes. Conciliator is more likely to actively suggest options for the parties to consider in circumstances where the parties hadn't considered those options themselves. And I guess finally, a conciliator may have jurisdiction under legislation as a result of being appointed to do so, to make directions or orders, say in a tribunal or court setting or through some other means. So the mediator is there to, if you like, from a technical perspective, to empower the parties, whereas a conciliator can move between the power model and the empowerment model. And you would have read about that in the material that we've provided, the difference between power mode and empowerment mode. So I hope you can understand that. All right, I know I'm moving fairly quickly, but are there any questions so far? We're all pretty clear. If we had a question on the difference between conciliation and mediation, we'd be able to write 1,000 words without even looking at a textbook. All good? All right. So conciliation would be suitable where the parties can benefit from the intervention of a third party. Conciliation might lend itself to a dispute that involves technical or legal issues. But still, the participants want to retain some control, but have some confidential discussions, but not necessarily they look to full litigation. Conciliation works with legal representation for both parties or not. It can work either way. And it's a flexible process. So don't think of conciliation as necessarily having to be face-to-face. Jackie will tell us it works over the phone just as well. It might even be by telephone through correspondence as well. The opening statement in a conciliation is very similar to the opening statement in a mediation. So it's really only down the track that we see the key differences between the two. And in some ways, they're not obvious differences, and depending on the way in which the conciliation operates or transpires, it may in fact be very much like a mediation session.
John, just a quick question.
Yes, Nicholas.
Then, is it possible during a conciliation for the ADR practitioner to suggest what possible legal ramifications or outcomes may be when two parties have asked for a conciliation in regards to, let's say, where a child may live if the child is living with party A on a temporary basis because the child's parents had just died? What would happen in that scenario?
Well, it's a very specific one. Looking at that question in the more general sense, yes, a conciliator is likely, I think, to provide some idea as to what might happen if the matter proceeds to litigation. I think that's quite common. In terms of the specific material in relation to parenting, that's a little tougher in individual cases. But I think the way in which a conciliator is likely to deal with that situation is to be very proactive, keep coming back to the best interests of the child, Section 65E considerations, and approaching it that way, without necessarily saying this is what the end result will be, may through his or her statements guide the parties to think about what's a likely scenario without necessarily saying this is it. Bear in mind, of course, that a conciliator is not there to be determinative. So the conciliator can provide some input of legal issues, some indication of what the issues should be considered, but not likely to have a final result. I know it's a grey area. What I do in conciliations, and Jackie might be the same, if it looks like you're not going to be successful in having a full resolution, I always ensure that at least we identify the material facts, the key issues, the questions that the parties want the tribunal or court or commission to answer when the matter goes to a hearing, so that the conciliation is not entirely lost. You really can't do that as a mediator. You can't take that much control. It's a very long answer and probably not a direct answer to your question, Nicholas, but I hope that helps.
No, well, it's along the lines of what I was thinking, John, because if two parties were to come together in line to have questions answered, they obviously want to mediate the issue, and they would realise that when it comes to a child's welfare in the end, in the scenario I outlined, the court would have to make the final decision. So number one, they would need to be aware of that probably before they came to conciliation, where the idea behind conciliation would be for them to put down their points between each other and argue their points as to why they think the child should end up with them, so that they can get their points established and hopefully come to an agreement before it gets to the court process where it's analysed by the court itself.
Yes, certainly a lot to be said for that. So, no, I agree with that. So thank you very much, Nicholas. And just in that family law sphere, there is a difference between a conciliation conference and a case assessment conference. The conciliation conference usually occurs after the case assessment conference. That's primarily to do with financial issues, but parenting can also be considered in that space as well. Just a few words about the Fair Work Commission. Jackie, do you want to give us a hand on this?
Yeah, sure.
Okay. So what I've got here is what I wanted to do is talk about preparing for a conciliation conference. Am I putting you on the spot to perhaps give us a few thoughts about what you like people to do in terms of what they should, how they should prepare for the conciliation?
Well, so we have a process anyway.
Mm-hmm.
So the applicant would fill out a form F2, which is then, so it's submitted to the Commission initially. It's got to be within a 21-day time frame. So 21 days from date of dismissal, if it's an unfair dismissal. That then gets served on the respondent, who then will provide us with an F3 employer response, which stays with the Commission and goes to the applicant plus any representative. And then obviously all that documentation I read before I actually hold the conciliation. But look, at the end of the day, I don't get too tied down in the detail because I'm not there to make a decision. I'm just there to try and facilitate the discussions and see whether we can reach an outcome. But at the very least, I will have read the F2 and F3 plus any supplementary information. But for the applicant to prepare, really, if they're going to do it properly, then I would expect them to have some idea of the outcome that they're looking for. But it doesn't always happen.
That's very important. I love it when people prepare a document for the purpose of the mediation or the conciliation. Certainly in court or tribunal hearings, as a determination or say a sentence matter, I'll always aim at least to prepare written outlines. And I think it's an underused, not tactic, it's not the right word, it gives the wrong impression, but an underused procedure to prepare written submissions or an outline for a mediation session. And people need to do that, I think, so that they're very clear about what are the material issues, what are the material facts, and what, importantly, do they want. So thank you, Jackie. Anything further on that?
I guess the other thing is just to add a little bit to what Nicholas was saying earlier. So we definitely, so if an applicant's not represented specifically and they really don't have an idea, I would play a very key role in suggesting to them the types of outcomes that could be available, such as dismissal, change to resignation, statement of service, obviously some form of financial compensation, not always, those sorts of things. Generally with unfair dismissal, it is financial compensation, resignation, statement of service, sometimes a separation certificate. You don't really get a lot of reinstatements I think I've done around 1,000 conciliations now, and I've only had 3 reinstatements in about 1,000. Yes. So there you go. And if it does go on to arbitrate, so my part of the process with conciliation, if it doesn't resolve, it's up to the applicant to let me know what they want to do. They can either, so I can keep the matter open so negotiations can continue between the parties, or they can withdraw, the applicant can withdraw or discontinue, or it gets referred to arbitration, in which case there are limited outcomes available once it goes there.
Excellent. Thank you, Jackie. I appreciate that.
Worries.
And fairness is a key issue. Jackie referred to that. Bryson talks about procedural fairness and content fairness. in the material that's provided in the study guides. And all of this is wrapped around ethical practice. So do some reading there. In the further material, have a look at some commentary about the power and empowerment models of conciliation. And there's a diagrammatic representation, I think, in the study guide, or if not, in the material by Bryson. So the task is to determine the issues and positions, to undertake some interrogation carefully, involves some persuasion, involves some carrot and stick techniques in a conciliation that you mightn't otherwise do in a mediation session. And empowerment model is a little different in that a little more like a mediation session, you're trying to empower the parties to come up with their own methodology for determining the result. In many of the jurisdictions, there's now a requirement for the parties to make a genuine effort to participate in the process in a meaningful way. And what that means is that conciliators sometimes have an ability to make a certificate or provide a certificate or feedback, not as to the content of what occurred, but whether in fact, in their view, the parties did make a genuine effort to settle. And there are a few cases in the material. Have a look at Superior IP International against Ahern Fox patent. It's 2012 Federal Court of Australia 282 FCA. The Federal Court viewed a party's failure to meet their obligations to take genuine steps as a serious matter. What do you think one of the main ramifications of failure to take genuine steps might be?
Cost orders.
Costs, exactly. That's exactly what I was after. Thank you, Nicholas. So bear in mind, of course, that if you're representing a client who fails to participate in ADR and thereby fails to demonstrate a genuine effort, they might win, but they may get a serious caning in terms of costs. So in that case of Superior IP International, there was a claim. It was made under the Civil Dispute Resolution Act, and the court said that the object of the Act was to take genuine steps before the proceedings are instituted, and that the Act further requires the parties to file a genuine steps statement. So if the requirements of the Act are not fulfilled, that question of costs looms large. We see something similar in family law conferences, and there's the Section 60I certificate, where a family dispute practitioner may provide a certificate to the effect that a person both attended a family dispute resolution with a practitioner, or with the ADR practitioner, that is, and that they made genuine effort to resolve the issues. Mind you, the certificate can go the other way and say that they did not make a genuine effort to resolve the issues. What
kind of mediation do they, what sort of ADR process do they use for the family?
Conciliation. Yeah. So generally conciliation, it can be mediation, but it's certainly generally a conciliation type arrangement. And we tend to see those ADR practices that are annexed to courts or tribunals tend to be conciliations, so that there's a little bit more directive power given to the ADR practitioner.
John, in that respect, I noticed that Justice Ip also made the same sort of comments in Copperlinger versus Flum Proprietary Limited when he was talking about cost orders. He specifically made a statement in the regards to if a party to an extended procedure under, I think it's Section 031A of the Act, adopts an obstructive or uncooperative attitude in the attempt to sort of negotiate, then a cost order will be awarded against them, no ifs and buts. He said if they don't participate, he would have automatically made a cost order, and that's his suggestion. And coming from Justice Ip, I would suggest that's a pretty fair line to follow.
Very good. Thank you very much for that. I appreciate that, Nicholas. What I've noticed in the time that I've been practicing is that whereas at the start people were very quick to pull the trigger, very quick to go to court, almost as if to create a bargaining position to put pressure on the other side. That's changed now. So even in circumstances where there is not a statutory requirement to undertake genuine efforts, the thinking has permeated more broadly, so that there's much more focus now on practitioners generally to undertake ADR practices. And thank you, Nicholas, for that case. I wasn't familiar with it. So it's CAPOLINGUA against PHLUM, Plum, Pty Ltd, 1989 5 WAR 137. Thank you. All right, if you want some further information about genuine efforts, have a look at NADRAC, and there's some information there about the expectation on parties to undertake genuine efforts to resolve disputes. So NADRAC, it no longer exists per se, but as you would have seen, we still refer back to that material on a regular basis. Okay, let's move on then to another issue, and that is arbitration, which is really the week 6 material, chapter 4 in your text. So arbitration, where does that fit in the continuum of ADR procedures from the least interventionist to the most interventionist procedures? Where do you think it sits? Most, yes. So it's right up there. It's the closest thing, in fact, to courts. So an arbitration is close to court proceedings. Arguably, some people say it was not even ADR. I think it is, because it depends what you mean by ADR. I think it's an alternative to a litigated dispute before a court or a tribunal. So the outcome of arbitration is a determination. So very different to conciliation or mediation. Can anyone tell me what the outcome is? Is it a decision? Is it an order? Or is it something else? So the arbitrator comes up with a decision and says, here is my decision, and it's in the form of a document which says, here is what the parties will now do. Here is we've got order is the only vote. The word I'm looking for is an award. So award, there it is, yeah. So the arbitrator will come up with an award, which is, if you like, the decision. The arbitrator hears evidence, and the arbitrator, unlike a court, can adopt, if you like, an inquisitorial process. Can arbitrate with pleadings or without pleadings, can arbitrate on the documents alone without a hearing. So there's a fair degree of flexibility. But the idea is that two parties, as it were, present their case, generally provide evidence, and as a result of that, the arbitrator will make a decision, which is called an award. By way of background, have a look at the United Nations Commission on International Trade Law, UNCITRAL, which provides a model, and the model law assists the states in reforming and modernising their laws on arbitral procedures to take into account the needs of international commercial arbitration. And like areas of, say, environmental law, we see this international sphere filter down into the domestic sphere. So the international commercial arbitration principles, which are part of the UNCITRAL, United Nations model law, has filtered down into the domestic jurisdiction. So arbitration has its roots, if you like, at its core in commercial disputes. So we don't often, traditionally we don't often hear of disputes on a more domestic level, but that is changing, and changing quickly. So even though I've suggested that arbitration has its roots, and still in very many ways does have its core strengths in commercial law, has anyone done any reading about where arbitration is becoming increasingly popular in a non-commercial setting? for dispute resolution. Any thoughts? Building contracts, says Craig. Yes, certainly popular, but employment, says B. I'll have to check with Jackie on that one. Still the one I'm thinking of. Family law is the one that I'm thinking of. And family law is increasingly going to be an area of new practice, new work for ADR practitioners as arbitrators, as decision makers. Now, when it comes to the definition of arbitration, again, have a look at NADRAC, always a good place to start. If you're answering any theoretical question on ADR practices generally, you can't go too far wrong if you include something from NADRAC by way of a definition. So arbitration is the process where the parties to a dispute present arguments and evidence to a dispute resolution practitioner, that is the arbitrator, who decides, makes a decision, which is called an award. But it's unlike litigation, even though it has many of the hallmarks. Firstly, it's private. Almost all litigation conducted in Australia, in terms of a hearing, is open to the public, almost all of it. Whereas arbitration is private. Arbitration can be voluntary or it can be mandatory. So again, we're seeing increasing situations where, if you like, the work of judges and tribunal members is being outsourced to arbitrators, whether the parties like it or not, in some instances. But like a judge or a member of a tribunal, an arbitrator needs to be impartial, needs to be a third party, and of course needs to base the decision on law. It's not a case of just hearing the evidence and saying, well, I think we'll award $10,000 in favour of A, next case. You need to go more. You need to do more than that. So an arbitrator needs to provide a decision based on law and be able to support that decision based on law, which usually means providing some form of formal decision in writing. Arbitrators are often experts in the field. Now, I think Craig mentioned building disputes, and that's an ideal situation where an arbitrator, as an expert in the field, is able to get to the core of the issues quickly and make a decision with a lot of background information and knowledge. But it's fair to say that most arbitrators would be barristers, solicitors, retired judges. So when you're looking at the arbitration issue, by all means compare it with other forms of ADR, but it's probably the one out of all the procedures that we'll talk about during this unit where you need to directly compare it with litigation. So something outside ADR. One of the similarities between arbitration and litigation is that it's adversarial. Now, I mentioned before that the arbitrator might adopt an inquisitorial approach, but do that within an adversarial paradigm. I hope that makes some sense. What I'm really trying to say is that you're going to have the two parties that present their case. They still have a positive obligation to present their case, present their evidence. But more so than a judge or a tribunal member, the arbitrator can inquire, can adopt an inquisitorial approach and ask questions directly. Now, the parties get some say in this. So not every arbitration is the same. Some arbitrations adopt a very court-like feel, even to the extent of agreeing that the rules of evidence will apply. Other arbitrations have a far more relaxed feel, and the arbitrator may inform his or herself or arbitrators may be able to inform themselves as they see fit. It's similar also in that very often lawyers are involved in arguing before an arbitrator on behalf of a client. but it's different because of the privacy aspect of it. All right, any questions so far?
Yeah, I've just got
Yes,
a question
Douglas.
in regards to that. So is an arbitrator then allowed to subpoena evidence? Are they allowed to go that far?
Yes, the parties can subpoena evidence. The arbitrator can call for evidence as well. And we'll talk more about that shortly, particularly in the context of commercial arbitration and the Act. So when you're looking at arbitration, don't just read it in isolation. Actively read it, comparing it with litigation, and if you like, come up with a checklist of what's similar between arbitration and litigation, and then think about it against other forms of ADR, particularly expert appraisal. So I would like you to come up with like these columns, and that'll make it easier if you get a take-home exam that deals with these sorts of differences, particularly in the context of trying to advise a client, which is the preferred option for them. So where it's similar between arbitration and litigation is that parties argue a case and it's adversarial and lawyers are involved typically. Where it's different, for court-ordered arbitration, it may be mandatory, but otherwise it's voluntary. Either way, it'll be private, although the outcome may become public. The arbitrator might be selected by the parties compared to a judge who is simply allocated to the job, and the result is binding on the parties to the case, so there's no precedent value. So you can imagine if you're acting for a party that is very concerned about adverse publicity, very concerned about precedent value associated with a claim made against it, it may opt for or push for arbitration so that it can gain some of those benefits as opposed to court. Now, I mentioned expert appraisal, so think about the difference and the similarities between arbitration and expert appraisal. So expert appraisal is a process where an ADR practitioner is selected, and usually selected on their expert knowledge of the subject matter, which is why they're called an expert appraiser, and their role is to investigate the dispute. So it's a little more interventionalist than in arbitration, where the parties present their case and the arbitrator makes a decision. So in expert appraisal, the expert appraiser has this role of investigating, and the appraiser provides advice on the facts and possible and desirable outcomes and the means by which they can be achieved. Again, have a look at the NADRAC definition. So you can see so far that I want you to compare and contrast these three models of determining disputes: expert appraisal, arbitration, and litigation. Arbitration sits in the middle of those two. Now, there is some legislative basis at a Commonwealth level for arbitration. Can anyone tell me what that legislative basis for the Commonwealth to make laws about arbitration might be? Where would we find that?
In the Constitution.
Thanks, B. Yes. And is it an absolute entitlement for the Commonwealth to make laws in relation to arbitration? Or is it limited? And if so, how is it limited?
It's only limited to interstate disputes.
That's a good point. It's not the answer I was looking for, but you're right. There is that power in the Constitution. Monique says Constitution re-employment. Yes. So under Section 51, subsection 35, arbitration relates to employer-employee disputes. I don't know why the Constitution was framed in that manner. It seems to me as though that was the only basis upon which people considered arbitration might be relevant. Otherwise, I can't see any particular reason why it was limited only to employment disputes. So can I ask you this question? And I agree with you, Monique, that's correct. And I agree with you, B. So it's in the Constitution. The Commonwealth has power to make Commonwealth laws in relation to arbitration, but only in relation to employer-employee disputes. Has anyone come across the uniform Commercial Arbitration Act. Does anyone come up? So you'll need to look at the Commercial Arbitration Act 2013. B says based on referral powers. Actually, what it was this: because the Constitution didn't directly allow for the Commonwealth to pass laws in relation to arbitration per se, what it did was coordinate through COAG the assistance of all the states to come up with uniform laws. So we've seen that a bit in terms of consumer laws and other legislation. So essentially, it makes sense, because if we're talking about commercial arbitration, commercial disputes, they're going to cross boundaries very quickly. So it makes an awful lot of sense to have uniform laws. So thank you, Nicholas. So the Commercial Arbitration Act 2013. I'm going to go through that Act now to some degree. So if you have an opportunity to look at the legislation as we proceed, please do so. If you're looking at this as a recorded session, have a look at the Act now. The Commercial Arbitration Act 2013, it's Queensland's version of the uniform legislation adopted by the states and territories. It is based on the 2006 United Nations Commission on International Trade Law, which is what I mentioned before. I call it UNCITRAL, but I'm not sure if that is the pronunciation. But it's a model law. Have a look at section 1AC, which is the paramount object of the Act, to facilitate the fair and final resolution of commercial disputes by an impartial arbitral tribunal without unnecessary delay or expense. It's interesting there that the wording is by an impartial arbitral tribunal as opposed to an arbitrator. So it's like tribunals and it's like some court proceedings. Now, if an arbitrator is approached as a potential arbitrator for a role in making a decision, it must disclose any circumstances that give any doubt or give rise to any doubts as to their impartiality or independence. Refer to section 12 of the Uniform Commercial Arbitration Act. Section 1 applies to the, it says that the Act applies to domestic commercial arbitrations. So the determination as to whether it's domestic or not is found within the same section, section 1, and the Act talks about a connection to Australia rather than to Queensland, even though it's a Queensland-based Act. So that emphasises the uniform nature of the legislation. Have a look at section 1, subsection 3, which says that arbitration is domestic if the parties to the agreement have, at the time of conclusion of the agreement, their place of business in Australia, and the parties have agreed that any dispute that might arise is to be settled by arbitration, and if not, an arbitration to which the model law applies. What's interesting there is that a couple of things. The first is that the parties need to agree with this. They need to consent. So increasingly we're seeing as a drafting technique in commercial transactions, documents that reflect commercial transactions, a reference to the fact that disputes will be referred to arbitration rather than to litigation. The second thing is that commercial is not defined. And have a look at Spencer. On that point, your textbook at 4.50, where Spencer says, interestingly, the names of the acts, referring to the Uniform Commercial Arbitration Acts, somewhat a misnomer because there's no restriction to invoking the acts based on the subject matter of the dispute. In other words, the acts can be invoked whether the dispute is commercial in nature or not. The word commercial could be removed from the title of the act and not affect the operation in the slightest. So that's what Spencer says at 4.50. I'm yet to be convinced that that's entirely correct when one considers the footnote to section 1, subsection 1 of the Act, which gives some indication as to the meaning of commercial in these terms. And it refers to model law note and says, the term commercial should be given a wide interpretation so as to cover matters arising from all relationships of a commercial nature, whether contractual or not. Relationships of a commercial nature include, but not limited to, transactions for supplier exchange of goods or services, distribution agreements, commercial representation, factoring, leasing, and so on and so on. So, to me, there is still that commercial flavour, and in that regard, I would consider what Mr. Spencer says in the book with some degree of caution. But the sort of question that you might get about the advantages and disadvantages of arbitration, the first thing you need to do is consider the legislation. Second is consider whether the legislation is sufficient to allow the arbitrator to make the award and have power to do so under that Act. So does it fit? Does the dispute fit within the parameters of the Act? So invoking the Uniform Acts, the Acts are invoked when the parties enter into an arbitration agreement or legislation has empowered a court to refer matters to arbitration under the Acts. So bear in mind that courts will often refer matters to arbitration, and we're seeing that more regularly even in the family law sphere. So any questions so far? All good? Okay. Now the arbitration agreement must be in writing, must be in a form of arbitration or in a form of arbitration clause in a contract or a separate agreement. Have a look at section 7 of the CAA. And very often it provides that the parties must arbitrate rather than litigate as part of their agreement. And if the dispute has an arbitration clause, the court must refer to the parties to arbitration unless it finds the agreement is null and void, inoperative or incapable of being performed. Have a look at section 8. So again, the decision of the parties from the outset to refer matters to arbitration is very important because the courts will uphold that decision and force the matter onto arbitration unless the agreement was null and void. So look also at section 5, which says that no court must intervene except where provided by the CAA, the Commercial Arbitration Act. And the Supreme Court has certain functions. Have a look at section 6. But the arbitration agreement or the agreement between the parties may provide that the district court has jurisdiction. So again, have a look at section 6. So section 9 is relevant because it provides that it is compatible with an arbitration agreement for a party to request before or during the arbitral proceedings for a court to provide interim measures of protection and the court to grant a measure. So in other words, even though I'm saying that the court will honour the agreement and compel the parties to attend the arbitration, the arbitrator must work within the bounds of the law, and the court, the Supreme Court, has the power to oversee what's happening, and therefore if there's a challenge made by a party as to something which is happening during the arbitration that they're not happy about, they can refer the matter to the court. So have a look at section 9. The court has extensive powers of oversight when a party challenges an arbitrator. But the arbitrator may be challenged in circumstances which give rise to justifiable doubts as to impartiality or independence, or if the arbitrator doesn't possess the qualifications agreed to by the parties. Have a look at section 12 subsection 3. There are justifiable doubts as to impartiality in certain circumstances, but only if there's a real danger of bias on the part of the party conducting the arbitration. If the arbitrator becomes, at law or in fact, simply unable to perform their functions or fail to perform the functions without undue delay, which is a cornerstone, the arbitrator's mandate terminates if the arbitrator withdraws or the parties agree on termination. Otherwise, one of the parties can ask the court to intervene. Have a look at section 14 of the Act. Now, also look at section 16 of the Act, which is about determining the existence or validity of the arbitration agreement or the jurisdiction of the arbitrator. And so the matter may be referred within 30 days to the court for a ruling on that matter. Now, where it gets really interesting and really court-like, I think, is where the arbitral tribunal, if you like, the arbitrator, has power to make interim measures, and they can be significant. So Nicholas asked before about the powers of an arbitrator. This is a really significant one. Who's undertaken civil procedure in the group? B has done. I can't see anyone else. B, the only one I can see on camera. Monique is doing that now. All right. So has anyone heard of a freezing order or a moraver order? Oh, you must be getting to that. Have a look at the UCPR Rule 260 Cap A, which talks about moraver orders. Also look at Practice Direction number 1 of 2007 concerning moraver orders. They're also known as moraver injunctions or asset protection orders. What Rule 260A says is that a court may make an order, which is a freezing order, to prevent frustration of the order of the court process by seeking the party to preserve assets so that if someone is successful against that party, they will have the prospect of actually having a judgment satisfied. So a freezing order can be made to restrain a respondent from removing assets located in or outside Australia and disposing of them or diminishing their value. So the court has power to make ancillary orders. So the arbitral tribunal may make an order against a party to provide a means of preserving assets out of which a subsequent award might be satisfied. So refer to section 17(2) subsection C of the Commercial Arbitration Act. So if you like, that is the same power as a court in terms of a freezing order. The other type of order that goes with it is an Anton Pillar order, which is a search order. You'll see this in Rule 261A of the UCPR, and the counterpart of that is 17 subsection 2D of the Commercial Arbitration Acts for an arbitral tribunal to make an order against a party to preserve evidence that may be relevant and material to the resolution of the dispute. So this search order that I'm talking about, which is Rule 261A, is also known as an Anton Pillar order. Basically, it provides the court with an opportunity to make an order, which is a search order, in any proceeding or even an anticipated proceeding to preserve or secure evidence and require the respondent to permit persons to enter premises for the purpose of securing and preserving that evidence relevant to the proceeding or the anticipated hearing. Have a look at Practice Direction number 2 of 2007, which concerns search orders, or as I said, also known as Anton Pillar orders, and read section 2D of the Commercial Arbitration Act. Now, these are really serious powers given to arbitrators, but you do need, I think, to look at the UCPR provisions and also do some background reading, have a look at the practice directions, because invariably the way in which the arbitrator is to go about its business, so to speak, will be in much the same way as the courts do in these corresponding orders. There are some conditions for granting interim measures. So have a look at section 17A, subsection 1, subsection 2. Have a look at 17E and 17F. So when a party asks for an interim measure, it must satisfy the arbitral tribunal that harm not adequately reparable by an award or damages is likely to result if the measure is not ordered, and there's a reasonable possibility that the requesting party will succeed on the merits of the claim. So that's very much along the lines of the tests that need to be considered by a court. And there's issues for security and disclosure. Then have a look at section 17 generally, which talks about the way in which arbitral tribunals has other powers to deal with interim measures. So they may be to deal with security for costs, discovery of documents, giving evidence by affidavits, inspection of property, taking of photographs or taking samples, or other type issues of a preliminary nature. Have a look at section 18 of the Act, which deals with the equal treatment of parties. Section 19 talks about the determination of rules of procedure. Section 21 talks about the triggers for an arbitration, and it says that unless otherwise agreed by the parties, the arbitral proceedings in respect of a dispute commence on the date on which the respondent receives a request for that dispute to be referred to arbitration. So there are some procedural steps. Firstly, the parties must appoint a suitably qualified person. Do so quickly, otherwise the arbitration will be void. Consider Oakland against Benaim, that's B-E-N-A-I-M, Oakland against Benaim, English decision 1953 to QB, Queen's Bench, 261. Delegation of the arbitrator's power is only allowed if authorised by the agreement. The arbitrator does have additional powers, coming back to what Nicholas asked. The arbitrator may order disclosure from the parties to do so within the terms of the agreement. The arbitrator can make other orders, can actually dissolve partnerships, grant equitable relief, decide matters on the papers, and is not necessarily bound by the rules of evidence. So have a look at section 19, subsection 3 in that regard. The arbitrator does have power to grant adjournments, but only if natural justice dictates it's appropriate to do so. The arbitrator can allow consideration from a party to present their case. And the procedure is adversarial, as I mentioned before, and the arbitrator therefore has a duty to allow cross-examination of witnesses. That's something that is expected and very court-like. Now, that might do us for this evening. And next week we can pick up in terms of what happens if a party wants to set aside an arbitrator's award. So before we round off for this evening, any questions, comments? All good?
Yeah, I've got one final one, John. How much of this are we going to need to know just in advance for the end of term paper? Will it be relevant?
Yeah. Well, it's always funny because I know what's there, but I think arbitration. I'll say this: arbitration is a very interesting area. So it would be worthwhile to have a good look at arbitration.
Would we be having sort of essay questions, or are we answering some kind of a scenario?
Yep. I usually like a scenario. I won't go, but I will give more hints as we get closer to the event. But those of you that have worked with me in the past probably know that I like scenario questions, but not necessarily. It might change. Good questions though. Any other questions? All good? Okay. All right, well, we'll wrap it up for this evening. We'll see you next week. Please do a lot of reading around arbitration, and we'll pick up on this again next week on the topic of setting aside an arbitrator's award. Okay, all the best. Bye then.